2, and after notice to the petitioners and opposite party number 5.
Yes, my lord.
And giving them a hearing, a reasoned order shall be passed thereon not later than 10th April 2023 and be made available to the parties within a week thereafter. The court clarifies that does not express in the matter.
Obliged.
Item number 2.
On Mr. The Patnaik is on accommodation, my lords. That's why, due to some personal difficulty, my lords.
Last time also it was adjourned.
Yes, my lords. I just received an instruction from his clerk, my lord. That's all.
Receiving instruction from his clerk.
There are associate, my lords. Associate, my lords.
You are asked to mention on
Yes.
behalf of.
Yes, my lords. Okay, expired goods.
So
One
all
of
this,
his
whether
family has
GST should be collected from opposite party number 5 or from you, this can't be made subject matter of a writ petition.
Also.
You have other remedies, sir. As and when the demand is raised, you have to challenge it.
Your lordship. And
You say-
except 2 is the assessment
Yeah.
order under section 6.
Yeah, whether the GST should be collected from the petitioner or opposite party number 5 cannot be made subject matter of a writ petition. As and when any demand is raised, it will be open to the petitioner to challenge it in accordance with law. In appropriate proceedings, the petition is disposed of.
I'm going to OP 1.
All right, all right.
Item
Just
number
give us your appearance, sir.
Item number 3.
May I please, Lordship?
And for opposite pen now 2 in that case.
Lordship, in this case, I have challenged the 148 notice under annexure 1, page 14, Lordship. Assessment here is 1314 and the date of issuance of order is 30th March 2021. Lordship, I have annexed the similar order, Lordship, covered matter, Lordship, annex page 47.
All right.
Your Lordship, Supreme Court has already admitted this 140 after 6 years has already been admitted. I am just passing the High Court order and the Supreme Court order.
That's right, only issue notice. That's
Yes,
all.
my lords.
Ah.
Tag with the batch of matter.
Yeah, again, same thing will happen, so. No stay, so we'll follow our order, then you'll take this also.
But you Lordship record because
Ah,
Ambika is not.
hmm.
Ambika you have not challenged.
yes, all that has been challenged.
All-
Tag with the last 138 something lot that has been tagged also.
All right.
May I suggest, Your Lordship, interim protection may be given so that after some time if we dispose of.
Sorry?
Will also give interim protection till not completion of the Supreme Court proceedings so that.
No,
Otherwise you have
no, otherwise everything gets messed up completely. It's better to have it all one shot done. You see, although the court has been shown copy of the order dated 20th January 2023 passed by the Supreme Court of India in SLP Civil Diary number 39003 of 2022 bracket Principal Commissioner of Income Tax Sambalpur versus Om Prakash Podar, which is a department's SLP against the order dated 14 March 2022 of this court. In writ petition civil 5818 of 2022, the court notes that no stay has been granted of the order of this court, paragraph. Following the order dated 14 March 2022 of this court, the impugned notice and all consequential steps thereunder stand quashed. The writ petition is allowed, no orders is to pass.
Lordship, the consequential order may be.
Then that's it.
Item number 4.
On behalf of Mr. Das, my lord, I am submitting. Counter has not received.
I'm in the connected matter. It's regarding irregular allotment of plot, ignoring the claim or.
No, none of you is for the petitioner.
Petition.
It is, you are for the
Yes, my
petitioner.
lord, I am
Ah.
aspect. In the first item, I am here, my lord.
I'm for the connected it petition.
Aha.
Yes, my lord.
All of you are for petitioners.
Yes.
Yes, yes.
Aha.
So he, my senior is for the opposite party number 1.
Item number 2, I am for the opposite person number 1.
One of you come this side, sir. Otherwise, all of you stand together. It's confusing. Ah.
There has been a specific order to the land allotment committee to file their counter. Repeatedly, Lordship had directed twice, but as on the state has not come out with a counter.
Actually, my role came into picture after the land has been given to me by the LSC. But therefore, on the last occasion, your lordship directed LSC to file a counter affidavit. Land
Who's
allotment
appearing
committee.
for LAC?
This may not. LSC has to. OP number 2. OP number 3.
Same thing, sir. I think despite last opportunity granted to, this is in 19482 of 2021. Despite last opportunity granted to the land acquisition collector to file a reply within 8 weeks on 21st September 2022, till date, no such affidavit has been filed. Paragraph, if the said affidavit is not filed on or before 1st April, 3rd April, 2023, then 25 costs of rupees 25,000 will be paid to the Orissa High Court Advocates Welfare Fund, and proof of payment of costs will be placed in record. In such event, the LAC will remain present in virtual mode before this court. The land allotment committee, is it?
Yes,
Not land acquisition officer. The land allotment committee, Roadkill,
Headed by RDC.
headed by the Revenue Divisional Commissioner, right?
My lord, may I beg
RDC.
your lordship's pardon, my lord? Earlier, my lord, the RDC was heading LSC, my lord. By the time the REIT application has been filed, RDC is no more heading the LSC, my lord, but the collector Sundargarh is heading the LSC.
All right, headed by the collector. The collector will remain present in virtual mode before the court on the next date.
Interim order.
This is 27662.
No, in 19482, because 27662, no such order was there.
Yes, yes.
In only 19482. Because the others will follow this. I think it's a similar petitions.
The interim order to continue.
Second.
In 19482.
Yes. 15/7/2000.
Interim order to continue. Rejoinder, if any, before the next date. List on. Eighteenth April.
Item number 5. 18th April.
My lords, here in the writ petition, petitioner challenges the first appellate order under GST Act, my
All right,
lords.
you pay 10%.
My lords.
All right. Subject to 20% within 4 weeks, no coercive steps. List on. May.
Item number 6.
Informed under annexure 4 series, my lord, passed under 63 of the GST Act, my lord. It is appealable under section 107, but due to attachment of the bank account, the petitioner are unable to pay the pre-deposit required under section 107, my lord. So only prayer is that let the vacate the attachment. So appeal.
Your lordship, this is the order, the writ petition has been filed after 1 year. Only that is the default, your lordship. We may file appeal and deposit.
All right. The counsel of the petitioner points out that the petitioner is unable to avail the appellate remedy under the GST Act against the impugned assessment order, since its bank account stands frozen. And there's no way it can make a payment of the pre-deposit amount. Where is your bank attachment notice?
Annexure 2, my lord.
Notice, he accepts notice. Paragraph. Having heard learned counsel of the parties, the court directs that limited to the amount necessary for making the what is the amount needed for pre-deposit?
10% of demand, my lord. The demand is
10% of the demanded tax.
my lord.
That is 20 lakhs 30,669. So 10% it will be amount
2 lakhs.
2 lakhs
Okay,
3,000.
limited to the amount of the pre-deposit requirement. The bank account of the petitioner, which stands attached in form of a letter dated 15 July 2022 addressed to the bank by the additional CT and GST officer, Kionjar, bracket annexure 2 bracket, shall remain lifted. Full stop. In other words, the bank will permit the petitioner to operate the said bank account only for the purposes of making the withdrawing in the pre-deposit amount and for nothing else. Full stop. Once that transaction is done, the attachment will continue and will be subject to further orders that may be passed by the appellate authority in accordance with law.
The provision says if 10% is depositor, the bank attachment to be.
To that extent, they will allow you to.
Paragraph. The delay in filing the appeal, in explaining the delay in filing the appeal, it will be open to the petitioner to state the reason on account of the pendency of the present petition. That will be considered in accordance with law by the appellate authority.
Yes.
The court clarifies it as not expressed in even the matter. The writ petition is disposed of. A copy of this order be sent forthwith by the registry to the branch manager, State Bank of India, Andapur, Kionjar. There are 3 banks here. Which bank do you want attachment lifted?
The State Bank, only the annexed to my lords. That's the state.
The State Bank of India, Bank of India, HDFC.
The 3 banks matter.
No, which bank you want attachment lifted? What is the balance in each account?
One bank will be at the State Bank of India, maybe.
All right, State Bank. All right. Andapur, Kionjar. Right.
Yeah, problem.
Item number 7.
Item number 7 is the PIL.
Fake doctors issue,
pertaining to fake
where
doctors.
on the last occasion, my lord had directed them to submit a report.
Well, the disciplinary inquiry that is being undertaken, that will be completed before March 2023. That is the timeline that has been given, my lords. And the second show cause notice has already been issued on 23rd of December 2022. And steps are being taken to comply with the timeline. My lords, with regard to the survey, my lords, if my lords comes to page 5 of my affidavit, my lords. So, para 4, my lords, if I may read.
Yes.
It is submitted that a survey to ascertain the authenticity of the qualifications and documents possessed by every allopathic doctor practicing in the state will be undertaken by the CDM and PHOs of the districts of all government facilities and private hospitals registered under
No,
the.
all this has to be issued with a timetable, sir. If you just have an open-ended thing like this,
Please, my lords.
how will they comply with it? They'll take their own sweet time to
No,
do
my
it.
lords, this will be complied within 6 months. My lords, the time.
No. That is a time limit set by us.
Please, my lords.
Unless you give within that 6 months timelines.
My lords may see the letters that we have given. My lords may see page 10. This is, my lords, the letter, if I may read, the type, it is requested to ensure medical registration, renewal of medical registration certificate and registration of additional qualifications working under your administrative control by 10th January 2023.
How is it even practical?
No, my lords.
We're not asking, this is not a timeline for them to submit original certificates for
No, my lords.
verification.
My lords, if I may apprise, my lords, the department has sent, these letters are being sent to every medical institution where, my lords, doctors are practicing, and a timeline is given, and thereafter.
Where is the timeline, sir?
It's the 10th January.
It's not the timeline. You're mistaking. Just read what is written there.
Please ask for updated.
It is ensure medical registration renewal.
Please, my lords. Of the practitioners.
What we are asking for is many of them are practicing under fake certificates.
Please.
Those have to be verified,
Please.
which means you ask the doctor to produce the original.
Please.
The sentence doesn't ask them to do that, and it can't be done within 10 days. It's all impractical. So you can't write a letter on 26th December and say by 10th January, all your doctors will produce. You're not even asking that. Where is that asked?
Well, it's the next letter may be seen. The next page, page 11. This is also 26th of December.
So by now you should have finished both By 7th January, you asked one letter, and by 10th January, you asked for another.
Yes.
Today, we are on 27th
Yes,
January. It should be over now, everywhere, all over, Orissa.
No,
No. You are saying this is the timeline.
Please.
So by now, everything is over, all over Orissa.
No, this is.
What, when I'm asking timeline, what is that? What does the court mean when you say timeline?
that
If
we
the
have-
court anticipated this will take 6 months, you've done it in 1 week. I mean, what are you trying to tell us? You've already completed the whole exercise.
No, Milaj, I've requested the Secretary Health Department to be present. She's present. my lord.
Let's see.
Namaskar, sir.
Namaskar,
This is actually- Sir, this is not the survey. This
Ah.
is doctors already practicing with us as a preliminary measure. We asked
Ah.
them to renew that they already registered practitioners to renew
Ah.
the registration with the Odisha Medical Council,
Right.
Council of Medical Registration. Sir, we have submitted here in the paragraph 4 that it is the survey to ascertain authenticity will be started. We have submitted our intention, sir. We will be, once it is this methodology is accepted, we will issue the letters and make sure that this is completed well before 6 months. We have given our intention. If this is acceptable to the Honorable Court, we will go
No.
ahead and ensure.
See, unless we have clarity on the timelines, merely saying it is acceptable to us will not serve the purpose. See, what are the timelines? You'll have to ask each of them to complete. First of all, issue notices saying, please come and furnish your originals, right? You'll have to
Yes,
give them an outer limit. You'll have to give them an outer limit. You'll have to undertake the allocate persons who will do the verification. Let's say I produce an MBBS certificate from Utkal University. All right.
Sir,
How will you know if it's an authentic certificate?
so it
You'll
is.
you'll have to verify with the Utkal University, correct?
Yes, the Council of
Ah.
Medical Registration will
So you'll
clarify
have to
with the
talk
issuing
to,
authority.
yeah, so you'll have to, you do not know what kind of certificates you're going to get. I'm saying, have you thought out the whole, you have to chalk out a whole plan, madam.
We will make a calendar, sir, and we will also give the public notices that calendar by which date the notice will be issued, by which date the compliance will be received, by which date it will be verified. We will
Correct.
work it out and issue it within, so we can issue it by tomorrow. That is, it is already worked out with our team. We have
Okay.
discussed this in detail with our team,
All
and the intention was stated here in the affidavit, but that letter can be issued by tomorrow because we have got the detailing done with us already.
All right. All right. So can you instruct your counsel here, then he can place it on record before us? How you propose to go about this whole exercise? All right. You can file a supplementary affidavit.
Yes.
Yes,
Yes.
within a
Ah.
Uh, we have given a short note.
Mm.
My lord would see as a long-term measure at point number B,
Hmm.
there is a suggestion, let them look into it
Hmm.
to have a online database of,
Hmm.
so that
Hmm.
people can cross-check.
Hmm.
Then at point number C, we have said, suggested that regular inspection, because their affidavit
Hmm.
says that existing practitioners would be asked to give documents.
Yeah.
But what about the establishment? So probably they need to have inspections
Hmm.
with a team of people.
Right.
And there are 5 reports, all of recent,
Origin. Correct.
where these fake practice. So probably these needs to be prosecuted. These regular prosecutions have to be done by them.
Initiated. Right.
So these 5 instances we have given, from
Hmm.
mostly these are from the remote corners of the state.
Hmm.
These coastal areas, probably people are more vigilant.
Right.
But if my lord would see those newspaper reports, page 4, these are of course newspaper reports.
Right. Fake doctors.
Then page 6 is 16th October 2022.
Right.
This has come out in Mirror now from Malkangiri. Then
Ganjam.
page 9 is Ganjam. That's 6th August 2022.
different places.
Then next one is Mayurbhanj at page 15.
So which will be the agency that prosecutes? Ms. Pandit can tell us.
Sir, if these are quacks and not
Ah.
registered or without any degree altogether, this will be with the police, sir. The police will prosecute
Okay.
them.
All right. All right. All right.
But these are the issues which probably they need to also look into. The common man is probably affected more by these.
Sir, what we are proposing is we have got established clinical establishments that are
Hmm.
registered, we
Hmm.
have to ensure also that anybody practicing, for example, whether it's a government hospital, a private hospital, a clinic, or nursing home, or even a diagnostic center, these are clinical establishments.
Right.
Everyone working there has to be qualified and registered, so people are not taken for a ride. That is a commitment, and that is a calendar we will give out.
All
But
right.
if there is a quack who is not with any establishment, just running around and doing without any degree, that the police will take action, sir.
I know, but you will, I think once you carry out the inspection, you will bring it to the notice of the police and they will take action, correct?
So yes, with our establishments, we can do that. Yes, sir.
Right, right. And then there is another variety. A person having Ayurvedic certificate passes off as an allopathic doctor. I don't know if those kind of issues arise in Orissa because it was there in other states, Punjab and Delhi. Somebody has only an Ayurvedic degree, but he's simply calling himself Dr. So-and-so, sometimes putting MBBS also.
Wherever, if during our survey, any of this comes to our notice, we will definitely take action.
All right.
And the specific instances which also have been pointed out, so we will take the action.
All right.
They have to have a mechanism in place where if they detect a fake doctor, then they have to just immediately constitute and.
All right. This court has perused the affidavit dated 25th January 2023 of the Special Secretary Medical Services, Health and Family Welfare Department, Government of Orissa, in response to the directions issued by the court on 21st December 2022. Full stop. Ms. Shalini Pandit, the Additional Chief Secretary Health, has also participated online. Mr. Gautam Mishra, Senior Counsel in Amicus Curiae, has also submitted a convenience note paragraph. As regards the direction issued in para 2 about completing the inquiry within a period of 3 months, the affidavit of the Special Secretary assures that it will be completed within the time stipulated by this court. Paragraph. As regards the verification exercise asked to be undertaken and completed within a period of 6 months, Ms. Pandit states that the necessary instructions have already been issued to all the CDMOs. What is PHO?
Chief District Medical and Public Health Officer.
And Chief District Medical and Public Health Officers of all government facilities and private hospitals registered under Orissa Clinical Establishments Control and Regulation Act 1991. Full stop. Paragraph. However, since the affidavit is silent on the precise timelines for completion of various steps involved in the exercise, a direction is issued that a supplementary affidavit will be filed, setting out the precise timelines within which the entire exercise will be completed. Paragraph. The learned amicus curiae suggested creation of a comprehensive online database of all medical practitioners in the state of Orissa, which will be accessible to the general public to cross-check the genuineness of all medical practitioners. Full stop. The state government will consider implementing this suggestion as well. Paragraph. Ms. Pandit assures the court that as part of the exercise, the state government will be conducting regular inspections of medical establishments to ensure that the existing medical practitioners have updated licenses and produce and possess genuine qualifications. Full stop. She further states that as and when there is any malpractice detected, the law enforcement machinery will be promptly activated. Full stop. This is in particular reference to the note of the amicus curiae, drawing attention to at least 5 recent instances in the districts of Ganjam, Rayagada, Mayurbhanj, and Malkangiri, where fake doctors are were found to have been carrying on medical practice. Paragraph. The supplementary affidavit be filed not later than 20th February 2023. So we'll give a longer timeline. We'll have it on the opening then. 22nd June.
Please, please.
22nd June. Thank you, Ms. Pandit.
Thanks.
You are all great.
Item number 8.
You know, see, on the last occasion, wanted to see the photocopies, recent photocopies of the. This photocopies. Art.
Vetanala.
Yes.
Pathetic essay. Seen this?
No, I have not seen.
You should give him copies, sir.
Just
What
one.
is this
copy
way
I
of?
got. Just one copy I got. They might have some information.
You got one copy. There is Justice Raman, there's me, there's Mr. Naik, there's Mr. Monty. You don't have a copy now. You're giving us, so you don't have a copy. How will you argue?
That is.
How will you argue? Say you remember. You know, you remember which is the fourth photograph here? You don't. So how are you supposed to argue?
I did seen from these photocopies. You know, they are not giving proper maintenance and cleaning.
So your very convenient way of arguing is don't answer the question.
Yeah.
That's the best way of arguing. Don't answer the question. Pretend as if you've not heard a question. Have I asked you a question? No. I didn't ask you a question.
I will start copy.
Aha. When will you do that, sir?
By tomorrow I'll give.
See, this is today's hearing, gone. You wasted hearing. You wasted today's hearing, right? Because you did not make enough copies of this. Even for my learned brother, you don't have copies. You are saying two judges, let them share one copy. No. Why should we bother?
My lord, take it at 2 p.m. I will stop.
So at your convenience, we should just keep doing things.
2 p.m. there is no court. My lord,
3 p.m.
your lordship may kindly see, in the last affidavit, we have already stated that fund has been allotted and tender call has been already, vendor has been invited, and the renovation work, he knows that it is very soon it will be started. That is the affidavit of the chief engineer, and the fund of rupees 36 crores, something odd, has already been allotted by
No,
the.
all that is actual action on the ground, sir. See, we have
they-
lots of things on paper, but it has to happen on the ground.
Then your lordship I can file affidavit that.
When did you take these photographs?
24th this month.
So which means
No,
nothing is happening.
Work has not been started, perhaps that is why. But because there are some prerequisites which have to be complied. That tender
Again,
call-
same thing, sir. Timeline. If you don't have timelines, we don't know when it will be completed.
No, so far as completion is concerned.
Brother Raman is absolutely right. Before monsoon, if you don't complete it, the same problem.
No,
Before Raja,
No, I understand, my lord.
we are
But-
now
yes.
heading towards
But
February.
only the contract has to be signed with the contractor.
So only 4 months left. 3.5 months.
As far as my experience, so it will take some time because it's a big patanalo, is a
So-
big.
So you have to start
3.5
somewhere.
months.
Yes, that your lordship is correct. Starting point should be definite. And that I will get specific instruction
The
from.
photographs of the Peta Nala shown to us by counsel of the petitioner leave much to be desired. Full stop. These were apparently taken on 24th January 2023 and have been shared with counsel for the CMC as well as counsel to the state. Full stop. Paragraph. Mr. D.K. Monty, learned AG, assures the court that a definite timeline will be drawn up for commencement of the work and completion of the work of renovation cleaning of the Nala. The affidavit indicating the timeline be filed not later than 13th February 2023. The court would like to impress upon the state government that the work should start as quickly as possible. And substantial progress should be made before the commencement of the monsoons. List on 29th March. So next time, copies for everybody.
First copy.
Item number 9.
Lord, I am for the petitioner, I am appearing virtually.
Right.
Your Lordship, see order dated 23/11/2020. The private opposite parties have taken an adjournment to their responses.
Well, I have already filed the counter.
When?
He has not served a copy.
I'll serve the copy by Monday, my lord, 23/12/2022. By Monday, I will serve the copy.
The counter affidavit is opposite party number 8 be served on counsel of the petitioner during the course of the day. Rejoinder that if any be filed before the next date.
Lord, may I pray for a short date to be fixed so that we can finish off this?
Yes, yes.
For OP number 6, our appearance may be recorded.
March 20 March.
Item number 10.
Item number 10, my lord, I am on receipt for the petitioner.
Yes.
My lord, I am still struggling to speak. My lord, your lordship may keep it to.
All right, all right. Counsel for the petitioner is unwell. List on 20th April, sir. Is there an interim order?
No, my lord, only.
All right, all right, all right, all right. Same with both matters.
Item 11.
Your lordship, item number 11, your lordship, 4 more weeks may be required for filing of counter, your lordship. It is the against that first appeal order.
But already
Interim order is there.
tax has already been paid, your lordship.
Interim order is there and.
All right. Mr. Mishra seeks and is granted 8 more weeks to file a reply, rejoinder for the next date. Interim order to continue. 17th August.
That's nice.
Supplementary list, fresh admission, item number 1. WPC 2920 2020.
I am from the virtual mirror.
Yes.
The last occasion, the London Standing Council was.
Yes. I have obtained instruction Paravai's comments right now. I will file. It is a very peculiar dispute, your lordship. He has encroached upon a government land.
Oh, I see.
Which is of Rasta Kisam, road Kisam, and we don't want to take his private land. He is insisting that you take my private land and under direct purchase scheme, and he will encroach upon the government land. Actually, that government land is required for the purpose. And this is the dispute. And the specific instruction is that we don't want to take his private land under direct purchase scheme because we have got a government land and it is under the municipal area, town area. He cannot encroach upon like this. We will evict him and we will have our road over that land, which is encroached by him. He cannot say that you purchase my private land and construct the road, which is not required by us. That is the sum and substance. And if your lordship will say, I will file an affidavit to that.
All right. Mr. Mohanty states that he will file an affidavit explaining the situation within 2 weeks.
Yes, ma'am.
With an advance copy to counsel, the petitioner is permitted to file a rejoinder thereto before the next date. 17th March. 17th March, sir.
My lord, we are proceeding with the road work. He is not allowing us because he has. There is no interim order. There is no interim.
No interim order. You go ahead.
Yes, that's.
No, my lord. My lord, you may kindly see. My lord has passed the order. Page 41, may kindly see. Page 41.
Interim order.
I have filed. My lord, for correction of the map, they have stated 2 things, my lord. prior to this case, my lord, page 31, may kindly see the collector, same collector, past that, I have enclosed 5 dismissal of landed property. And my lord, when that case was remanded to the same
So if
collector.
any coercive, we said if any coercive action is taken, he can come to the court. That's how he's come. He anticipates this.
Okay, but there is no stay order or status quo.
No, it says the idea is that if coercive action is taken, he should come to the
Because
court.
our board work is.
Then we'll have it earlier.
Yes, madam.
My lord, in the meantime, my lord, kindly see page 41. My lord has passed the order.
Then 17th February. Okay, 17th February, sir.
17th February.
17th February.
Filed, my lord, for correction of the map, my lord. And that is pending, my lord. And my lord stated that if they will take any action, that will be taken into consideration, and I will raise that before the appropriate authority, my lord.
17th.
And my lord has passed the order on page 41, may kindly see on 12/5 to 21.
All right, sir.
Item 2.
If I may please your lordship, this application pertains to extension of time of arbitration, your lordship. The stage of
Who's the other side?
it hasn't been admitted, your lordship.
No. This is an IA, sir. There's a question of admission.
Yeah.
Who's the other side?
Other
In the
side is-
arbitration.
Your lordship, the main record has been transferred to the record room, your lordship. That's why I was not able to trace the record.
In the arbitration, whom are you for?
I am for the claimant, your lordship.
Claimant. So there's obviously an opposite party
Yes, your lordship.
in the arbitration.
Yes, your lordship.
That opposite party was represented by whom in the main matter?
That, your lordship, I was not able to trace it. your
No.
lordship.
It's there in the impugned order itself, sir.
Mm. No, your lordship, it isn't in the impugned order, your lordship.
Acha, despite service of, no, but somebody must be appearing in the arbitration.
Yes, your lordship.
Who's appearing?
I'll take instructions, your lordship. I have no instruction.
To
regarding-
whom notice will go? If you don't mention, whom should notice go to?
Yeah.
Anyway, notice to the non-applicant returnable 17th February, the Astin edition. All right. In the IA.
Item number.
Much obliged, your lordship.
Item number 3.
Mediation, what happened?
I'm for the opposite party, madam.
Non-starter. Next date is fixed as 3rd February. Who's the other side?
And I am for the opposite party.
You are for the?
I am for the opposite party.
You are Birat Chandra Dagra.
Yes, madam.
You were present, but the petitioner was not present.
Petitioner is not present.
No. Petitioner is present with his counsel, opposite party is absent. You were present, but your party was not present.
Yes, madam.
So will you be present next hearing?
Yes, madam.
3rd February is the date for mediation.
Yes,
All right.
madam.
The mediation report has been perused. The next date there is 3rd February. List on 3rd March.
Obliged.
Item number 4.
Item 4, my lord, today, course of the day, we're filing the counter.
All right. Mr. Party says the counter will be filed in the course of the day, rejoinder before the next date.
Mr. Kashyap is appearing with me, lord.
3rd March.
Short date, my lord.
3rd March is 1 month away, sir. We are already 27th January.
In February, my lord.
Before you can say February will be over. Time flies. 3rd March.
SS Kashyap, my
Item 5.
Item 5, madam.
my lord.
The arbitration notice is at page 18, my lord.
Here also we'll file the counter, the CPW.
Same. All right. Mr. Party states he'll be filing counter affidavit within a week. Rejoinder before the next date. 3rd March.
Let's give 10 days time for filing counter.
All right, within 10
They have
days.
already taken a time earlier. madam.
I know.
It has once to have taken this.
Come back from Supreme Court and again, another second round.
Mr. D.R. Bhukta is appearing with me in this case, along with me.
All right.
Special list, trace admission, item number 1, CRLMC 615 of 2016.
None appears dismissed.
Special list, item number 2. Item 2.
None appears dismissed.
Special list, item number 3.
Permitted to withdraw.
Dismiss is withdrawn.
Item number 4.
None appears dismissed.
Special list, item number 5.
None appears dismissed.
Special list, item number 6.
None appears dismissed.
Special list, item number 7.
None appears dismissed.
Special list, item number 8.
None appears dismissed.
Special list, item number 9.
Same order.
Special list, item 10.
Same order.
Special list, item 11.
The petitioner against whom a summon has been issued by the learned trial magistrate that why you will not be prosecuted under the Prevention Corruption Act and also some of the provisions of the IPC and also EC Act. The case is certain quantities of rice, paddy were found short during investigation by the police.
That's it.
That matters related to EC Act. I was no way concerned in the particular incident. My name doesn't appear in the FIR. Subsequently, when charge sheet was submitted, my name appeared, accordingly I was summoned.
Who are you?
I am the inspector under the authority, that is the Essential Commodities Act, Supply Act. My duty was assigned that I will just remain present during the measurement, which I did. And during measurement, when it came to my notice that some shortage is there, I also somewhat initiated one case on the Essential Commodities Act before the collector.
Always apply for discharge, sir.
I have applied for discharge. I have applied for, I have no case at all.
I know. Let the trial court look into it, sir.
He has looked into and said that from the ingredients, I found there is a privacy case.
That's all. I'm saying apply for discharge.
That is my
Discharge
difference.
That is cognizance taking,
Yes,
sir.
sir. That
Discharge
I
is
know.
a different stage.
Your worship may give me liberty that I can again agitate this matter.
All right.
Oblige.
Liberty is granted to the petitioner to urge all points raised in this petition at the appropriate stage in the trial court. The petition is disposed of, interim orders vacated. Right.
Item number 12.
Oblige.
None appears dismissed.
Item number 13.
Same order.
Item number 14.
13. Ah.
I filed this case to quash the proceeding, my lord. There were 4 accused persons. Out of 2 accused persons faced the trial, and they have been acquitted, my lord.
Then you have to show that judgment, you'll also get acquitted. Simple, sir. Why we should quash now?
My lord, NBW has been issued.
You appear on a day. You tell me which date you will appear. 1st March.
My lord. Kindly
The
direct and I
petitioner
may
will
be
appear on
released.
1st March in the trial court.
My lord.
And further proceedings will continue in accordance with law thereafter.
My lord, if I will
The
surrender.
interim order is vacated. The petitioner is permitted to raise all the pleas raised in the present petition, the appropriate stage in the trial court. The petition is disposed of.
My lord, I may be directed to surrender and release on bail.
1st March. All right.
Item 14.
None appears dismissed.
Item number 15.
None appears dismissed.
Item number 16.
16, my lord, permitted to be withdrawn.
Dismisses, withdraw. All right.
Item number 17.
None appears dismissed.
Item number 18.
None appears dismissed.
Item number 19.
May please your lordship, my lord, permit to withdraw.
Dismisses, withdraw.
Item number 20.
Your lordship, item 20, permission to withdraw, your lordship.
All right. Dismisses, withdraw.
Item 21.
My lords, may give me a short pass over. My senior is on
All
his way.
All right.
Oblige, your lordship.
Item 22.
Item 80 is already missing. My senior's mother is today expired. Kindly to accept her. Item 8, specialist.
All right. Item 18, you say the requester comes from the petitioner. List on 17th March.
Oblige.
Item 22.
None appears dismissed.
Item number 23.
I plead your lordship. Lordship, here the petitioner has prayed for quashing of the criminal proceeding on the ground that initially in the FIR, the petitioner has not been named in the FIR, and in the charge sheet, their name has been included. And moreover, there is a civil dispute between the parties, and as well as a preventive proceeding under section 107 is CRPC is there. And the petitioners are the ladies members, and there is a counter case between the parties. Arising out of civil dispute, the petitioners are ladies.
You can raise all the pleas, sir, at the appropriate stage. Permitting the petitioner to raise all pleas at the appropriate stage, the trial court. The petition is disposed of, the interim order is vacated.
Item number 24.
Not pressed, your lordship. Not pressed, dismissed. Interim
Item
order vacated.
25.
25, my lord, permitted to withdraw with the to raise our objections.
All right. Permitted to raise all pleas at the appropriate stage. Interim order vacated.
Item 26.
None appears dismissed.
Item number 27.
None appears dismissed.
Item number 28.
None appears dismissed.
Item 29.
29 may please. As in that case, my lordship, the present petition praying to quash and set aside the entire criminal proceeding against the present petition, my lordship. In that the present petitioner alleged that the amount has been, the loan has been granted by the bank, my lordship, that was repaid by the present petitioner, and the no due certificate has been which is annexed in annexure 2, my lordship, page note 28.
You can point it to the trial court.
All I have all the 28, my lordship. In this is certified Jadumanandalai. Employee railway had availed a personal loan.
There is no stay by this court. Must be over by now, the case itself.
The account is also closed by the State Bank of India.
Then nothing remains. Permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed of. All right.
Item number 30.
May please, your lordship. Lord, here is a case where the petitioner ought to have been shown as a prosecution witness, rather he has been arraigned as an accused, my lord. I just 3 lines, I'll just state the facts. The complainant states that one of his co-sharer had sold a joint family property by showing his branch as issueless. So that declaration was wrong. Hence, he filed a suit for declaring that sale deed as void. Filed a petition suit, all the plaintiffs have annexed. My role is that I am an identifying witness in that sale deed.
What happened in the suit?
Suit is pending, my lord.
So it will be outcome of the suit, sir. You can always ask the trial court.
Yes, my lord, with that, yes, it is subject to result, outcome of the suit, my lord. So that may be observed.
Why should be? You go before the trial court. You are not going before the trial court at all. That's all.
I cannot now. I'm facing the trial, my lord. I cannot hear. I cannot.
There's no stay granted here, sir.
But the trial is pending. Mere by filing, I have intimated the trial court.
That's the whole problem.
Yes, my lord. So trial has not proceeded. Trial has not proceeded, my lord.
Now it should.
My lord knows attesting witness. My role is to identify.
You should speak before the trial court, sir. You're not even allowing that to happen.
My lord, the cognizance he should have. My lord, cognizance cannot be a mechanical one. He should apply his mind. My lord, see the cognizance order. He has not applied his mechanical. He is saying that yes, the case is made out without applying his mind, my lord. A bare look at the my lord, the affair and all this would that I am an attesting witness.
All right. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. The interim order is, and there's no interim order. All right.
Oblige.
My lord, sorry, my item number was passed 15.
15.
15.
You come later, sir. You've suddenly woken up.
Okay. Well, kindly take it in next week.
No, you have to wait till the board is over.
Okay.
Item 31,
The memo is taken on record. Dismisses withdrawn.
item 32,
None appears dismissed.
item number 33,
None appears dismissed.
item number 34,
Well, item number 31 matters become infructuous.
Infructuous disposed of.
item number 35,
If I may, I pay for not pressed one.
Not pressed. Dismissed is not pressed.
item number 36,
Memo taken on record. Dismisses not. No instructions.
item number 37,
The police issued the challenge the notice issued under section 41A of the CRPC. The police issue showing them as a convict issued the notice to the accused persons. So I have challenged this notice. Last occasion, this honorable court directed who had printed this notice and for taking instruction to the state councillors. Your Lordship, last occasion.
Yes. He's already acquitted, he says. Mr. Mohanty states that he needs some more time for instructions. Interim order to continue. List me for the roster bench on 1st May.
item number 38,
None appears dismissed.
item number 39,
Same order.
item number 40,
Same order.
item 41,
Same order.
item number 42,
Same order.
item number 43,
Your Lordship, item 43, permission to withdraw.
All right. Dismisses withdrawn.
Much obliged.
item number 44,
None appears dismissed.
item number 45,
My lord, I am paying for adjournment on the date due to death of Mr. Bibhudananda Mishra. I am at his residence, my lord. Our learned friend read bar.
All right. Constable, the petitioner is in some difficulty today. List me for the roster bench on 13th March, 1-3.
Deeply obliged.
item 46,
None appears dismissed.
item number 47,
Same order.
item number 48,
Same order.
item number 49,
May please your seat. My lord, challenging the order of taking cognizance under section 294, 506 of IPC and section 67 of IT Act and 14 of the POCSO Act, my lord. It is alleged that the petitioner took away the photograph of the victim on the eve of Ganesh Puja, my lord. Subsequently circulated his photograph in obscene remarks, my lord. And during the investigation was completed, my lord, charge sheet was submitted page 14, my lord, and it is reveals that website is a fake one, my lord. It has been mentioned in the charge sheet page 14, my lord. It is shown on him.
You applied for a discharge, sir, on that basis. Permitting the petitioner to raise all pleas at the appropriate stage in the trial court, the petition is disposed of, the interim order is vacated. Yes.
item number 50,
None appears dismissed.
item 51,
That's 51, not pressed for the time being. If any cause of action survives, I will again approach you, permitted to approach.
All right. Mr. Das states that he does not wish to press the petition at this stage. He seeks liberty to seek appropriate remedies if any fresh cause of action arises.
Obliged.
This is withdrawn with liberty is paid for. All right.
item number 52,
52, my lords, the wrong file has been taken. My lords, one adjournment, and in the meantime, I will take a step for conversion, my lords.
At the request of counsel, petitioner list before the roster bench on 6th March.
Obliged.
item number 53,
None appears dismissed.
item number 54,
Please, your lordship, I am for the opposite party.
All right. None appears to the petitioner dismissed.
item number 55,
Same. No, you just say dismissed, none appears dismissed.
Item 56,
Same order,
item 57,
same order.
item number 58.
May I please, your lordships? My lord, I have challenged that order passed in revision, which is in fact not maintainable as per section 397 clause 2 of CRPC, because that revision is against the interlocutory order. Your lordship may kindly see annexure 2 for a moment, page 15. On the application filed by the petitioner under section 133 CRPC, your lordships, one interim order was passed, interlocutory order was passed under annexure 2, which is challenged in revision. But the section 397 clause 2 CRPC says that against interlocutory order, no revision lies.
Is this coming up after notice or?
My lord?
Notice has been served. You are appealing for the opposite side. What is your plea? What is your answer? He says it's not maintainable at all. Revision petition according to him is not maintainable.
Yes, my lord.
What is your reply? Case law must be there. Supporting you. Where is that?
But I have not got if your lordship will take off next week.
Yes.
But the law says not pass.
Pass any order, man.
Counsel for the petitioner points out that the revision petition under section 379 CRPC, right?
397.
397 CRPC is not maintainable against an interlocutory order. Nevertheless, the Sessions Judge Puri registered criminal division number 18 of 2017 and passed an interim order on 23rd August 2017, which was entirely without jurisdiction. Paragraph. Despite notice having been issued in the present petition way back on 18 July 2018, till date, no counterpetitive has been filed by the opposite parties 2, 3, 4, and 5. Full stop. You are appearing for all 4.
My opposite party 3 only.
Oh, what about 2, 4, and 5?
That I.
So actually 2, 4, and 5 absent, hence return to sender. That's the remark. What do you wish to do then?
They have not appeared even if received of the notice.
So when the revision petition is listed, it will go for toss. Only he will be there. You can point out to the court there, it's not maintainable. Paragraph. Leaving it open to petitioner to raise all the pleas raised in present petition at the appropriate stage in the trial court. The interim order is vacated, the petition is disposed of. All right.
Your lordship may, I will liberty.
Yeah, it will be, the petitioner will be at liberty to point out to the Sessions Court Puri that the revision petition pending before it is itself not maintainable.
As per section 397.
Whatever, all that, we don't have to set out your whole arguments.
Here 4 items, item 54 to 57, I was not there. Because this was for non-president, actually no instruction.
They say no instructions. 54 to 57, dismissed.
Item 59.
None appears dismissed.
Item number 60.
Same order.
Item number 61.
My lord, no instruction. If cause of action survives, it may be reverted to grant.
No instruction, no instruction. No instructions dismissed. All right.
Item 62.
None appears dismissed.
Item 63.
None appears dismissed.
Item number 64.
Same order.
May I please, your lordship? My lord, this is an application for restoration of the criminal revision which has been dismissed for default. My lord, it is a revision against the order of conviction. My lord, that on the date of call, the advocate who was earlier appearing on behalf of the accused persons, my lord, he remained absent, for which your lordship has been pleased to dismiss it for non-prosecution. My lord, what I pray, your lordship may restore the case and place it.
What's the main matter?
My lord,
what is the main matter about?
Main matter is, my lord, there is a conviction under section 326 with other offences, my lord.
All right, for the reason stated, the order dated 27 June 2023 is recalled. 9 September 2022 is recalled, and criminal division 401 of 2003 is restored to file. In the main criminal division, you see, the present revision has been restored pursuant to an order passed today in criminal MA 353 of 2022.
In the meantime, my lord, warrant has been issued pursuant to your lordship's.
The bail order dated 27 June 2003 is restored to file,
Obliged.
as well as the stay order on realization of file. List before the roster bench on 13th March.
Item number 65.
None appears dismissed.
Item number 66.
Same order.
Item number 67.
67 and rate will be taken up next week.
Why?
Mr. Senior Advocate is not well, maybe taken up next week.
Senior counsel for the petitioner is stated to be unwell. List before the roster bench on 20th March, 20 March.
Obliged.
Interim order to continue.
Item number 68.
Your Lordship, the matter is infructuous.
Dismisses infructuous.
Item number 69.
Please, no instruction.
No instructions dismissed.
Item number 70.
Well, permitted to withdraw. Dismisses withdraw.
Item 71.
Item 71.
Although order of organized is under challenge, I pray Lordship may permit me to raise all the point eligible.
All right. Permitting the petition to raise all this. Interim order of cage.
The appropriate of trial Lords. Grateful Lords.
Item 72.
And double 80 matters. Both the matters, the parties are separate. And the order in both the cases have been, the order of organization in both the cases have been challenged in both the proceedings. And in one case, they are operating the practice.
All right. Permitting the parties to raise all the respective pleas at the appropriate stage. The petitions are disposed of, the interim order, and one of them is vacated. We permit you to raise all pleas at the appropriate stage. Yes.
Item 73.
73, pardon, my lord, I am on VC. My lord, quashing of the criminal proceeding or order of cognizance for offence under section 406, my lord, arising out of a complaint case. Petitioner is a lady, my lord. My lord, the opposite party number 2 gave a marriage proposal of his brother with this petitioner through a matrimonial site who could not proceed, my lord. My lord, ingredients for the alleged offence under section 406 IPC are totally absent, my lord. My lord, there is no whisper of allegation that the complainant has entrusted anything to the present petitioner or breach of trust in respect of such entrusted property, my lord.
Permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petition is disposed of. Right.
Item 74.
May please.
Yes.
In that case, Melissa, that the present petition challenging Melissa that the illegal and arbitrary order determined 23/6/2017 passed by the law and SDGM Balasur Melissa. In that case, Melissa, 2 case has been proceeding has been made. One is the present petition is the opposite party number in execution miss case number 109 of 2015 Melissa. And whereas the opposite party number is the petitioner in proceeding under section 421 of CRPC, which is pending for the law and SDGM Balasur. The allegation against the present petition, my lordship, that the allegation, my lordship, against the present petition that he has the present petition had taken a payment of 1,80,000 rupees from the complainant. That's the allegation. That has promised to repay the such amount.
There is no compromise between the parties, sir.
That I will take some instruction, my lordship. I will compromise.
No.
That I will
permitting the petition to raise all pleas.
just one.
No.
That's one adjournment. I will take some instruction. That
not this.
There is judgment passed in the 1CC case, and thereafter they preferred appeal.
Oh, I see.
That has been dismissed, and so also revision has been dismissed.
Oh, I see.
But he has to follow the.
Now the execution case is proceeding.
So you say permitting the petitioner.
He has to follow the under section 421 of CRPC and 387 of CRPC. Instead of doing this, they have taken the orders measure.
All right.
75.
I apologize, my lordship. That item number 29. I have just that item has surpassed my lordship. That item, my lordship, that the allegation against the present petition, there is nothing allegation. The evidence which has been presented by
Same, 29 permitting the petitioner to resolve.
Item 76. May I call? Pardon, 75. Item 75.
None appears dismissed.
Item 76.
My lord, in 76, I'm from the opposite part number 2, my lord.
None appears to the petitioner dismissed on opposition.
Item number 77.
77, my lord. The petition is a principal in charge. First of all, first complaint was filed in the year 2014. That has been ended in stating there insufficient evidence. Thereafter, they have filed second complaint case, for which I have filed this case. And I have to obtain the stay order in this case.
So it's only a cognizance taking order, sir.
Yes, my lord.
And the offense is under?
Offenses is under, my lord. That is annexure 2 at page 17.
471, sir.
471.
So 471 and all evidence is required. Can't be quashed.
Yes, my lord.
Permitting the petitioner to raise all pleas at the appropriate stage. The trial court, the petition is disposed of. All right.
Item 78.
At the stage of
Whatever stage, sir. We just said appropriate stage. All right.
May I please, may I please,
I want to say, sorry, I want to say that at the stage of charge, discharge.
Whichever stage, sir, we're not specifying which stage.
May I please, your lordships. My lord, here cognizance by order dated 2010-2011 at page 18.
What's the offense?
Section 494 and other allied offense 490 bygamy. Your lordship may kindly see. After divorce, I have got married. After divorce. So by 494, you will not at all be made out. Your lordship may kindly see.
So you point out that, sir. You can always point it out. Permitting the petitioner to raise all pleas at the appropriate stage in the trial court, the petition is disposed of. Right.
Item 79.
May. I'm challenging order dated 14/9/2017, my lord, page 31, my lord. Taking cognizance of offense, my lord.
Under
section 3 SC/ST Act is concerned, my lord. During the what happened, my lord, all are the petitioners are all are the police personnel, my lord. So petition number 2 and 3, my lord, there is no allegation, my lord, against the SC/ST Act is concerned or the other offense is concerned, my lord.
apply for discharge. Permitting the petitioner to raise all pleas at the appropriate stage. Interport of guilt.
Item 80. Obliged.
My lord, if petitioner is challenging the order dated 15/9/2017, wherein the London Court below has directed to pay interim maintenance of amount of rupees 8,000 to the opposite party. But my lord, I am paying rupees 5,000 as per the order passed by this honorable court on dated 3/4/2018. Still
Just
now,
account for inflation, sir. All this will easily be taken care of.
5,000 I'm paying. I'm ready to pay also that, my lord. So in that light, my kindly be disposed.
That was the interim order.
Yes, please. My lord, I'm paying, and till now also.
This what is 8,000 these days? Nobody can survive on 8,000.
Till now also I'm paying, my lord. So
You
that's
have to pay only 3,000 more, sir. Inflation you account for. 5,000 in 2018. Today it must be equivalent to 8,000.
so on that light may kindly be disposed
Given
of.
the amount of maintenance directed to be paid by the trial court, the court is not inclined to interfere.
And rather, I have filed a section 9 petition. Notice was been issued.
That's
but
okay.
the
That's a separate
wife
thing, sir.
is not inclined to come. So,
That's right.
and instead of that, he has
Since the
filed
order is
one.
vacated, the petition is disposed of.
Item number 81.
Lordship, item 1, liberty may be granted to raise all the points at appropriate stage.
Liberty.
Item 82.
None appears dismissed.
Item number 83.
May I please, your lordship? This is quashing of cognizance,
Hmm.
but this is a case where your lordship will see that should not have been a prosecution in the first place. I'm conscious, my lord, your lordship usually relegates, but this is a case 92 of the Factories Act. If your lordship will look at the complaint under Annexure 1, but the grievances that were raised has been remedied. And 101 of the Companies Act says that if I bring the persons who are responsible, then the proceeding is to be dropped so far as I am concerned. Because I happen to be the head, I have been booked. Now I have brought to the notice of the authorities who are the persons who are in charge. Instead of they being prosecuted, only because the petitioner happens to be the head of the organization, he is being prosecuted. So this is the my lord background. I filed a petition before the court below to drop the proceeding. He says your remedy is 482 not here. Your lordship may kindly only see page 24, my lord. He says you go in 482 CRPC, I cannot drop it. So therefore the problem, my lord.
No, there's no problem.
And it's not a my lord, it's a case where there has been some kind of irregularity while the my lord, some kind of mechanical defect while the furnace was being operated, for which he is no way personally responsible.
That is a matter of trials. Whether he was aware, whether it was within his knowledge.
One says I can bring and they can be prosecuted. There is a provision in the statute itself which says that I can bring to the notice of the authority and they can prosecute. I have done that. And despite that, I am being prosecuted. Now I was told by that I was taking instruction. Nobody is turning up so far as the complainant is concerned.
So then it will
I am facing a prosecution matter unnecessarily.
Then it will go, sir. Then it will go.
And this matter order may stand as a bar. Your lordship may clarify or at least raise at the stage of charge if a charge comes in matter.
Permitting the petitioner to raise all please raised at the proper stage in the trial court. The petition is disposed of. The interim order is vacated. All right.
Grateful, ma'am.
Item number 84.
None appears dismissed.
Item number 85.
Same order.
Item number 86.
Same order.
Item number 87.
Same order.
88 already taken. Item number 89.
My lord, 88.
No instructions dismissed.
Item number 90.
May I please, your lordship? There is a case, my lord, challenging the order of taking cognizance under section 493, 294, 506, 34 of IPC, my lord. In the meantime, my lord, the petitioner has already married the victim girl, opposite party number 2, my lord. In this regard, I will file affidavit, my lord. Lordship may kindly
counsel for the
2 weeks time, my lord.
Petitioner. But the marriage certificate is there already.
Marriage certificate is there, my lord.
And there's an affidavit before that. Naik.
As per Hindu marriage rules, my lord, page Annexure 6, page 26.
She has filed an affidavit. You say the affidavit of opposite party number 2
yes, ma'am,
is set Annexure 5, in which she states that she does not wish to pursue the complaint. Annexure 6 is the marriage registration certificate. Stop. There is no dispute on the genuineness of the above documents by any of the parties, including the state. That view of the matter, just take from the prayer clause, and all proceedings consequent thereto are hereby quashed.
Miller.
Allowed. Password.
Pardon to mention, lordship, item 43. The conducting counsel was expired, lordship, item 43. So kindly instead of non-appears, kindly be known.
Somebody has withdrawn this case. 43.
Yeah,
Somebody has
withdrawn
withdrawn.
Dismiss is withdrawn.
Obliged, lordship.
Item number 21. Passed order.
Fine.
But this is an application under section 482. Challenging the proceedings.
Yes, please.
Charge is under section 287, 337, 38, 304A. One proceeding going on before the Khurda court and the another under the Factories Act. Another provision under the Factories Act. And I've just passed on the judgment. Your lordships, the Honorable High Court of Jharkhand in identical matter. If your lordship will just have a look at the lacetum. This is Indian Penal Code 285, 287, 337, 338, and 304A. Except for 285, rest of the provisions have been mentioned in the charge sheet. And now if your lordship will just turn over and go to paragraph 5. This application has been filed for quashing of the entire criminal proceeding, including the first information report of Kandra PS number so-and-so registered under section so-and-so. Except for 285, rest of the provisions are all have been mentioned in the charge sheet. Now, if your lordship will have paragraph 8. Learned counsel appearing for the petitioner submits that the entire allegations made in the first info falls within the ambit of the provision as contained in section 92 of the Factories Act. And therefore, if any prosecution on account of negligence on the part of the management of the said factory lies under the Factories Act, which is a specialized legislation, and as such, provision of the said act would prevail over the provision of the general law. Now, if your lordship will go to 10, paragraph 10, a counter affidavit has been filed on behalf of the state, stating therein that due to negligence on the part of the management for not adopting safety measure, the occurrence took place, and as such, the petitioner is being rightly prosecuted. Having heard learned counsel appearing for there does not appear to be any doubt that the allegations upon which first information report was lodged come well within the ambit of the provision as enshrined under section 92 of the Factories Act, and as such, any prosecution under the general law in view of section 4 of the Code of Criminal is not permissible, while proposition of law has already been laid down in the case of so-and-so and so-and-so. And finally, the FIR is quashed. Now, if your lordship will just go to the, no counter affidavit has been filed, but if your lordship will go.
No, who's appearing?
To the charge sheet, it starts at page 19. And if your lordship will go.
Sir, Mr. Mahanti was supposed to do this case. I don't find the file, Lord, sir.
At the request of counsel for the state, list before the roster bench on 20th March, 20 March. I don't think there's an interim order.
No, there's an interim order.
Okay, interim order to continue.
Very great. Yeah.
Maybe pardon, my lord. My item number is item 40 and it was in other court. That's why.
40.
40, my lord. On behalf of Mr. Panda.
Tell us.
Yeah, that is, my lord. I'm here taking quashing of suo motu proceeding by subdivisional magistrate under section 133 of CRPC, my lord. My lord, I was working as a subdivisional officer under Westco, and I have been instructed to cut the power from 18 hours to 23rd by rotational wise. So I was working as Dharmagad and I was working as Junagadh. As the Dharmagad is under Junagadh area, so there the power cut is on 8 PM to 9 PM. And that is why I had proceeded on suddenly I had received a notice on 6/10/17 that I have to file a so-called why shall the power cut shall not be stopped, my lord. But it is not under my hand, my lord. It is the direction of SLDC that to cut the power, my lord. That is why the suo motu proceeding.
But you can point this out to the court. You can easily point it out to the court. Permitting the petitioner to raise all pleas raised at the appropriate stage. Raised here at the appropriate stage.
And raise all those points at the time.
Yes, yes. The interim order is okay.
Stay was there.
Yes, yes.
Thanks.